Hey guys, Toby Mathis here, and I want to give you an update on what's going on with the Corporate Transparency Act, the business owner information that has been such a controversy over the last couple of months and has been in court so often. So here's what's going on. This week, the court down in Texas, the appellate court, stayed the national injunction that was actually preventing the beneficial ownership information from being required to be filed under the Corporate Transparency Act. So as of right now, it's back. And the Corporate Transparency Act requirements for all companies is back. Now, we knew that this would likely happen. If you've been following my channel, I kind of said this is what was going to happen. What we did not know is how much time they were going to give us. So when I say they, that means FinCEN, the Financial Crimes Enforcement Network, the Treasury. And they're the ones that are responsible for the beneficial ownership information reporting. And they put out I'm going to put it up on the two things up on the screen right now. I'm going to share with you the order itself, which shows that the Smith case was the national injunction and that it was stayed pending the disposition of the appeal. And so here we have another situation where a judge signed a national order. The appellate court is staying it. Last time we kind of did a hokey pokey. The same appellate court reversed the reversal, and then the Supreme Court reversed that reversal. So there was the Texas Top Cop shop that caused such an uproar in December, right around Christmas. So it was early December that the injunction, then they undid it. Then right after Christmas, they put it back in place again. Then it went to the Supreme Court and they struck it down. But in the meantime, the Smith case snuck in. You can see it's Samantha Smith and Robert Means versus United States Department of the Treasury. Again, I'll put it up on the screen so you can see it. And it's really simple. It's the court has determined the motion should be, and it is hereby granted. It's the government's motion to stay pending appeal. And they cited the Supreme Court's order in the Texas Top Cop shop. So again, these cases kind of get intertwined. It's actually in the same Fifth Circuit. So it's kind of interesting that both came out of Texas. There's other courts have refused to grant injunctions. And there's one other injunction in Alabama where it was for a very specific class. Otherwise, the government's been winning all these. So we kind of said, oh, there's a couple courts have said no, and everybody else is saying yes. So, but FinCEN did put out a statement, and I'm going to put it up on the board here. I'll just share it again so you can see it. And I'm putting what's up there as of right now, today. And you could see right now, and it says, with the February 18th, 2025 decision by the U.S. District Court for Eastern District of Texas and Smith et al. V. U.S. Department of Treasury. That is the order that you just looked at. Beneficial ownership information reporting requirements under the Corporate Transparency Act are once again back in effect. It couldn't make it any more simple. Now, the big issue is you go down here to updated deadlines. So if you were required to file during that period of time, anytime from, it literally would have been anybody prior to 2024, your deadline was January 1st. And then it was stayed. So you had this injunction. So anybody who had a January, February deadline, your new deadline is March 21st. So that basically comes up and gives you 30 days to catch up. If you have a longer deadline because you were affected by a natural disaster, such as the hurricanes, then you use the later dates. So you don't have to do it by March 21st. But what this means in English to anybody out there who is holding off doing your Corporate Transparency Act filing, you are required to do it. And if your deadline was, I'll make sure that how they put it, reporting companies that were previously given a reporting deadline later than this March 21st can keep that. I'm seeing if they actually gave us. No, they just said actually if you had your reporting deadline by March 19th, then you have 30 extra calendar days. So you have until March 21st. which means, and they put it right here, for the vast majority of reporting companies, the new deadline to file initial updated and corrected report is March 21st. So who has to file any new entities in 2025, any entities that existed prior to 2024, and any entities that were filed towards the end of 2024 where their due date was stayed because of this. Your new due date is now March 21st, 2025. I think it's pretty clear. Again, we kind of thought it was coming. If you want to put your comments down there, there's always folks that think it's just an outrageous overreach of government. There is a bill that's passed the House to stop the Corporate Transparency Act, though it's been in force for 11 months of last year. There is a lot of uproar, a cry out about the amount of compliance paperwork that small companies have, especially like the Smith case was small little LLCs that just hold some real estate. That's a lot of our clients. And so FinCEN did say that they were going to see whether or not they could modify the requirements. And I'm just going to see if they actually put it in here. I remember reading it. And so that they can see, they're talking about modifying the amount of information that you have to file. So that's still on the table. They might reduce the scope of the paperwork that's required of small domestic companies. We will see. I would not be surprised if they came out just because of the uproar and modified it down to make it a lot easier for new companies. And this is what I keep telling people. If you are a small LLC, mom and pop LLC, this isn't additional information you're necessarily giving the government, right? I always get attacked when people do this, like you're just, kowtowing to the government. Hear my words really quickly. Bank Secrecy Act, they have to know who you are. They collect that data, they share it. The banks are going to be sharing the database that is being collected here. They have an arrangement where that they could say, hey, we're investigating, we want to get this information. But also when you file your tax return, it's going essentially to the same place, going to the Treasury. And you have a K-1 or it's going on your Schedule E. So they already know that you own that LLC and it's disregarded to your return or you're a partner in it. They already know that. This is really geared towards people playing straw man games where the actual controlling person is pretending that they're not the owner, but they're still in charge. And if the government can prove that, then it's much easier for them to get criminal sanctions against that individual when they're playing games. Now, yes, they are catching everybody up. I don't like it either. I'd rather have less compliance than more compliance, but I don't want you to think, oh my gosh, I'm losing my anonymity or they're violating my rights. Because in all reality, they already have this information. They said it during the hearings when the Corporate Transparency Act was being debated. They just said they didn't have a centralized database, an easy way to search. And they certainly didn't have these laws to attack money launderers. That's their auspices. Now, big companies somehow get out of this, right? So like if you're big enough, in theory, you don't have to comply with this stuff, but you're being caught by something else. Is I guess there's a bunch of exceptions of what type of companies don't have to file, like a nonprofit, non-filed entities, companies greater than $5 million, things like that. There's a bunch of them that say, oh, you're going to get hit someplace else. There's higher degrees of compliance when you have that type of money flowing through banking systems, for example. But for the small mom and pop, again, this isn't necessarily new information that they're getting. They're just getting it in a more searchable database, but they're not after them. And I think that's where Congress really needs to do its job and say, hey, you know what, you're looking at the wrong folks here, the people that are actually complying with this, the law-abiding citizens. That's not the money launderers, right? But the government kind of knows. They just want a tool so that they can say, hey, you failed to do this. The penalties are huge, guys. You don't file on time. It's almost $600 a day. It's a $10,000 fine and 2 years in jail. So you don't want to play around with this. But again, it's not for the little guy. I really think this is just a tool, kind of like they got Al Capone with tax charges. They want another tool to go after somebody that they may not be able to get on because they're using evasion techniques. They might not be able to get under typical laws, but they'd be able to get them under this statute. I think that's what they're doing. But we will see. Check back for updates. But again, the corporate transparency is back in effect as of this is February 2025. If you have a due date that falls anytime prior to this, your new due date is March 21st or later, depending if you were affected by a natural disaster. But more for most people, it's going to be that March 21st.